Well, good afternoon, everyone, and welcome to another FTB infrastructure seminar. We've got two presentations and three speakers today, and our three speakers each have considerable experience in infrastructure planning, both under the Planning Act 2008 and other regimes, and their experience covers a wide variety of infrastructure, including energy generation, road and rail schemes, ports and airports. In a moment, we'll be hearing from Andrew Fraser-Urquhart QC.
Good afternoon, everybody.
Considering some of the legal and practical issues associated with Section 35 directions. And as many of you will know, Section 35, potentially attractive route to consent for developers of major schemes at a time when the government is likely to be particularly keen on opportunities for stimulating economic growth and job creation. Afterwards, we'll be hearing from Howell Williams QC and Michael Fry, and they'll be giving a joint presentation on national policy statements. And this, of course, has been an area of considerable controversy, both in examinations and in the courts, and that looks set to continue for the remainder of this year and quite possibly beyond. Now, at the end of the two presentations, there will be a short session to respond to any questions that have been raised on the presentations that have been given this afternoon. There is a question and answer function on Zoom, which you'll hopefully find at the bottom of your screen. And it's quite easy to use, and I'd encourage you to use it during the course of the presentations. Just put your question on there, and when the speakers are finished, they'll have a chance to look at any questions that have been raised, and we'll try and deal with them at the end, or at least as many as we can in the time. The slides that are used today will be emailed out to all participants at the end, together with a link to a recording of the presentations, which is on Chamber's YouTube channel. So if you can't stay for all of it, or if you want to listen back and look at it again at your leisure, then that's something you'll be able to do. So with those introductory words out of the way, I'm now going to turn to Andrew, who can begin his presentation on Section 35. So we'll be seeing Craig and Michael again in due course, but over to you, Andrew.
Thank you very much indeed, Harry, and good afternoon, everybody. Let me just get the slides on screen for you. And we're away. I read somewhere in a review that the FTB webinar series was being described as the new Netflix, which was flattering, but suggested an odd sense of priority on the part of the author, perhaps. But in response to that, I've discovered that my titles for these presentations are becoming more and more end of the pier. And this one I've called Close, but Maybe Still a Cigar, as opposed to Close, but No Cigar, because this is all about Section 35, which gives the opportunity for promoters and others, as we'll see, to apply for a direction from the Secretary of State to have their project treated as a nationally significant infrastructure project for which the development consent order route is available. And I'm sure that basic is familiar to most of you, but we're going to look in a little bit of detail, I think, at the jurisdictional aspects, some aspects of good practice as we see it, as our experience has suggested, and then challenges to the Secretary of State's use of the direction power, of which there has been a recent example, which has illustrated many of the points which would appear to be of interest from the legislation. Now, I start by setting out on these slides some statutory words. I'm not going to read them all out to you. Anybody can do that, but just to pick up on some of the points which immediately appear from the statutory provisions. First of all, there's the basic power to give the direction as development being treated as development for which development consent is required, and thus the Planning Act 2008 route for consideration, subject to the provisions of the recently, or in 2013, inserted section 35ZA, which deals with various procedural matters. And then we see that there are in effect two entirely separate forms of development for which the direction may in due course be given. And it's important to note the difference because they present slightly different procedural and jurisdictional issues. The first is for a project in energy, transport, waste, wastewater or waste simpliciter. Now, these obviously are really forms of development which in their larger manifestations would inevitably in any event have to be treated as NSIPs and have to go down the DCO route. And to an extent, one can see there that there's an obvious basis for this jurisdiction in terms of those projects which do not quite meet the threshold, but which common sense and other matters might suggest are sensible for consideration under the DCO route. The second aspect is for business or commercial projects of a prescribed type. Now, this is a new departure from the original NSIP regime, and the list of those is important and bears scrutiny because it is not necessarily an entirely simple matter to work out what does and does not come within that list, and we'll look in just a moment at the prescribed list. Then the other crucial consideration is at C, which is the belief of the Secretary of State, and one observes immediately there that it is a matter for the Secretary of State's belief and thought, i.e., in other words, a discretion, as to whether or not the project is of national significance. And we just pause there to note that national significance is not a phrase which of itself benefits from a statutory definition. There is no statutory definition, which makes matters of, particularly the way one presents an application and then issues of challenges of some importance. So national significance, the Secretary of State thinking of national significance is the next really important consideration, and that may be the project of itself or the project in combination with other projects which fall within the same field. So there may be opportunities there of combination of projects seeking together to be regarded as of national significance and therefore going through the DCO route. So the definitions of infrastructure planning, business or commercial projects, these are the regulations from 2013. The projects must consist wholly or mainly of the following categories. Obviously, some of them are fairly obvious in terms of their meanings, others less so. For example, an industrial process or processes. Now, one interesting example that came to my attention a little while ago was the issue of what might happen if there were to be a very large film studio proposed, which would be regarded as being of potentially national significance, whether such a project could fall within any of these definitions. And it was necessary then to make reference to other guidances and other forms of statutory interpretation to see whether an industrial process might, for example, encompass that kind of activity. And there, for example, the definitions which are provided in the use classes order may be of some persuasive value, in that an industrial process there is defined rather more widely perhaps than one might envisage in terms of a layman's understanding of an industrial process. And just to follow through the example I've started with, one actually finds that the production of film and video facilities is regarded for the purposes of the use classes order, at least, as an industrial process. And so one sees there that this relatively short, sweet and somewhat bland list of definitions may require some, or indeed a good deal, of digging deeper in order to see what it contains in reality and what it would permit to be the subject of a direction. Item 10 I draw attention to is of some importance because this regime for a Section 35 direction is very explicit in its terminology about excluding housing. It also does not cover peat extraction, which is in fact one of the few things to which there is an absolute bar according to the NPPF, and significantly, of course, coal, oil or gas, which cannot fall within this Section 35 direction regime, and as I've said, housing. Now, the prohibition on housing comes from the Principal Act, and it prevents the Secretary of State in the list of commercial and business projects. It prevents the Secretary of State from prescribing in regulations a project which includes the construction of one or more dwellings. Now, that's on its face a very clear prohibition. We'll just explore what the boundaries of that might be a little later in this talk. And we note also that if the project is in London and is a business or commercial project, then the Mayor of London must also consent. So that, of course, again has obvious implications for the needs for consultation, persuasion and engagement, which is an essential part of this exercise. And then the next part of the statutory framework is Section 35ZA, which sets out the procedure which must be followed insofar as, and frankly there ain't much, but insofar as there is statutory guidance on the procedure, this is where one finds it. And with there again, one starts here to see the distinction between what I have termed through the rest of these slides infrastructure proper, so the energy, wastewater and so forth, the first part of the definition. One sees the distinction here between those types of infrastructure proper and the business and commercial schemes which could potentially fall within this regime in the following way. First of all, you can only make an application for a direction under Section 35 if you have not previously made an application for planning permission, or indeed various other forms of consent which are listed in Section 33 of the Act. But if you've made an application for planning permission for that kind of scheme, then that precludes you by 35(1) from making an application for a direction that the project be treated as an NSIP. So that's an all or nothing really. Whereas with a business or commercial project, and it may have been that this was intended as a sort of quasi-transitional provision to enable projects which had already had their genesis and for which applications had been made to switch routes. But in any event, the application can be made if one of the forms of consent, particularly planning permission, has already been applied for. However, the other difference is who can apply. For infrastructure proper, anybody can approach the Secretary of State and invite him or her to give a Section 35 direction to bring the proposed development within the DCO regime. By contrast, for business and commercial projects, there is a specified list from which is set out there, which effectively covers those who are going to be the promoters of the scheme. There are various ways of expressing it, but it's effectively the promoters. So only the promoters can make that application in the case of a business or commercial project. And then the Secretary of State has the power to make the direction, whether that's after planning permission has already been applied for a business or commercial, or in either case before planning permission has been applied for the business and commercial and the infrastructure proper regimes. Now, one important set of provisions in section 35 ZA are what I've described as the modification provisions, and they're really quite wide-ranging, and it's important to note them because it allows the Secretary of State, first of all, to make the direction for specified purposes or generally, but then in terms of individual applications, it allows the Secretary of State to make directions, in effect modifying the statutory process of the DCO regime. And so the power appears to be, in its statutory language at least, unconstrained, and therefore there may be considerable thought needed to be applied, first of all at the stage of making the Section 35 application, as to what possible modifications one might seek, either from the promoter's side, if it's a business or commercial project for which the promoter alone, as we've discussed, is allowed to apply, or more generally, if it's infrastructure proper, as to what anyone who's making that application might seek to have inserted or removed from the normally understood DCO process. Equally, the Secretary of State by 5B has power to regard certain steps as already having been taken, and that's clearly important if a promoter has started down the road and then, as it were, switched horses, as is permitted, particularly with the business or commercial route. The relevant authorities, who are effectively the authorities to whom a planning application would otherwise have been made, must cooperate with the Secretary of State by way of giving information to enable the Secretary of State to determine the request for a Section 35 direction, and they must, when the direction is given, unsurprisingly, to make the regime function, they must then refer the application to the Secretary of State. And then the final point to note from this trot through the statutory provisions is the Secretary of State must give reasons. There's a statutory duty to give reasons for decisions with respect to directions under Section 35, and those of you with judicial review hats on, your ears will immediately perk up on hearing that. So in terms of what I've described in this somewhat inelegant but highly useful modern phrase as the takeaways with respect to jurisdiction, first of all, as we've touched on, for infrastructure proper, third parties comply, but they can apply rather for such a direction, but you can't make such a direction if planning permission has already been applied for. By contrast, for business and commercial, it's promoters only, but it can be made after a planning permission has been applied for. Horses can be swapped. The fundamentally important requirement of national significance, and again, that is a matter for the opinion of the Secretary of State alone. Consent of the Mayor of London required for business and commercial proposals in London. As you'll have noticed, beyond some of the very bare bones, there's nothing by way of a prescribed procedure, and that is of some importance and value possibly. And then the importance of the modification provisions. I've touched on those in a little bit of detail. I think it is very important to appreciate the potential scope and risks of those modification provisions. And then finally, there's the absence, what appears to be in totality, from housing in this regime. So that's really what we learn from the statutory materials about the jurisdiction for making these Section 35 directions. Timetabling set out fairly briefly in section 35A, which is the only other remaining section of the Act dealing with this power, the primary deadline for the Secretary of State is to respond within 28 days of the receipt of the request, which in infrastructure terms is really pretty speedily. And so it is a process which enables for a fairly rapid decision. The Secretary of State can request further information within that 28 days from what I've called the requestor, because there may be different parties who are able to make this type of application. And then if the respondent provides that information within 14 days in response to the Secretary of State's request, then the Secretary of State has a further 28 days after the receipt of that information. Now, there's a rather odd lacuna within this legislation in that there is no specific provision dealing with what happens if a requestor does not provide requested information within that 14-day period. And 14 days is not necessarily that long for compiling information that the Secretary of State may want to have. And if you don't provide that information within 28 days, there doesn't appear then to be any fallback provision as to what the time limit might be, which is odd. And in theory gives the Secretary of State the ability to sit on his or her hands for as long as he or she wants, which is a rather odd position to arrive at, but certainly appears to be the consequence of the legislative provisions. So moving forward to practice, now there isn't a tremendous amount of guidance to be found about this power. There is some guidance from November 23 on the subject of the extension of the regime to business and commercial projects, which was at the very genesis really of the statutory process bringing this into play. And the guidance points to the relevance of a significant economic impact, or is important for driving growth in the economy. And pausing there, clearly all the noises coming out of central government now are with respect to build, 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 and so forth. And so the importance of the economic impact, I suspect, is going to rank very heavily in the scales of any decision that comes to be made with respect to this, or frankly any other decision that government has to make. And then some of the things which point towards the advantages of the DCO regime in any event. So whether the project has an impact across an area wider than the single local authority, substantial physical size, whether it is important of itself to the delivery of some other nationally significant infrastructure project. And then the perhaps unsurprising and frankly a simple statement of the law that the Secretary of State will consider any matter which he or she considers relevant, again in particular whether or not the regime would benefit from being treated through the NSIP DCO regime, which is in particular obviously the requirement or the requirement that a scheme might otherwise have to secure multiple consents or authorizations. And so therefore that's the sort of thing to focus on. And then finally the Secretary of State includes the cautionary note in the guidance, again not particularly surprising, that you would normally expect a project to be of substantial size before it merited treatment through this regime of the DCO regime, and therefore that's specifically pointed to, whilst not being a determinative factor, is nevertheless an important factor. And of course, it's likely that only a project of some reasonable significant size is likely to tick any of the other boxes and meet that fundamental threshold from the Act of being of national significance. So, procedural points to note. As I said, there's no set procedure. We've seen the full extent now of both the statutory procedure, such as it is, and the guidance, again, such as it is. Now, what has been seen is that only a simple letter is required for the net zero, the Teesside net zero project, for example. The letter that started the process, that made the application, formally made the application, was only a 15-page letter, which in the grand scheme of infrastructure projects is almost, well, it's pretty small. And so that's all that's required. There's no set time within the scope of the process at which an application can be made. And so subject obviously to necessary project definition and being internally satisfied that it's doable in every sense, there's no particular time at which one is required to make an application, other than, as I've noted on a couple of occasions, for infrastructure proper, that half of the regime, as it were, you can only apply before any application for planning permission is made. So there has to be a choice made there. The time limit point, I touched on that slightly odd lacuna in the legislation. And it's also very important to note that in terms of statute and procedure, there's no particular provision made for third parties to comment on the request. The Secretary of State can request information from the relevant authority. That's the authority to whom applications would otherwise have been made. But there's no other particular provision for third parties to comment on any request. So any consultation the Secretary of State might do would be entirely extra statutory. So, in terms of now some thoughts about practice in the light of what there is to learn from the statutory and other guidance materials, the first and most fundamental thing to consider is, do you want it? Do you want to go down the DCO route with your particular project? Now, obviously, these arguments as to the efficacy and benefits of the DCO regime are pretty well known, but they do need just a little bit of thinking about in the context of this ability to apply for Section 35 projects, and particularly, obviously, with respect to perhaps business and commercial schemes. Obviously, one of the primary advantages of the DCO route is the establishment of need for the project by the national policy statements, and we'll hear much more about those, of course, from Michael and Craig in due course. But given the wide scope, particularly of the business and commercial arm of the jurisdiction, there may not be an NPS, and you may not be able to get that particular benefit of going down the DCO route. By contrast, it is worth noting, in terms of the NPPF, there's a subtle but important change in the language of the NPPF between the original 2012 version and the 2018/19 version, which is this, that in the 2012 version, in the introductory paragraphs, I think it was paragraph 6 of the 2012 NPPF, the national policy statements, it was said that they are, for these terms they were now, they are a material consideration to which decision makers, even on planning applications, had to have regard. Now that's now been changed in the 2018/19 NPPF to the fact they may be material considerations to which regard has to be had. So again, there's an important possible change if you have an NPS which you think is favourable, or even parts of an NPS which, whilst not dealing directly with your project, may be of assistance in securing a consent. If you go down the planning application route, you're not guaranteed even to be able to persuade the decision maker that they are a material consideration, let alone carrying the weight which they obviously do in the normal DCO process. And so this nexus of the national policy statements, the NPPF, and then the type of development that one is proposing to embark upon is going to be a very important consideration, I think, in whether or not it's a good thing to go down the route of trying to secure a Section 35 direction. And again, it's sort of two sides of the same coin. In the second bullet point, I noticed that the policy regime established in the NPPS is often favourable, not just about need, but, for example, in the acknowledgement in the EN1 that energy infrastructure projects for which there is clearly a need are by definition bound, or almost bound, to have a pretty considerable impact on visual and landscape interests, and that sometimes has to be tolerated. That's a piece of policy language and support which doesn't readily appear in many local plans, and therefore is the kind of support that even a non-NSIP energy project can very much take advantage of. Under the old NPPF, when I was promoting the Veolia energy from waste scheme in Hertfordshire, which was vetoed on political grounds by the Secretary of State, no bitterness there. But when I was promoting that project, we made considerable use of the language in the NPS on energy in respect to the landscape impact. We had the benefit of the 2012 NPPF. If we'd not had that benefit, things might have been different. The other advantages of the DCO route are very familiar. The need for one consent, one decision maker, the sometimes higher profile that the NPS application will get, and therefore the ability perhaps to prod statutory undertakers into a more timely response in terms of getting all the ducks in the line, the set timings of the process, which have slipped a little bit recently, with rather more postponements of decisions than one has ever seen before, but generally still perceived to be a considerable advantage of the process. I've paused just to comment a little bit on the ability to apply for associated infrastructure. It might be, and I put it absolutely no higher than that one could, as it were, sneak in some related housing, although the statutory language establishing the regime is very clear that one or more dwellings are not permitted. You can't even have one dwelling. Through the application query whether you could sneak it in as associated infrastructure once you are either as part of your application or perhaps more likely after the application has been accepted. I flag that as a possibility, although I have to say I have real doubts as to whether, given the very clear apparent intention of the statute, whether or not that would be permitted. But in any event, it's something to think about. And more generally, the ability to include associated infrastructure is a well-known perceived advantage of the DCO route. So in terms of with that fundamental decision to go for it made, what are the good points of a decent application which might succeed? It's a little bit hard to tell from practical experience because there have really been relatively few, but what we know tends to suggest this. First of all, of course, early engagement with the Secretary of State, as with any NSIP or indeed other planning scheme. Early engagement with the decision maker is always a huge benefit. It's worth noticing, and one sees this from the NSIP, the PINS NSIP website, in fact, frequently asked question number 29, that in circumstances of preparing a possible Section 35 direction, it's not the pre-application service offered to, as it were, full-on DCOs, which is available. It's a direct liaison with the relevant Secretary of State who will actually be making the decision, both on the Section 35 application and thereafter, if you're successful on the DCO itself. And so that is the way to go about engagement, not through the pre-application service. Obviously, if you're in London doing a business and commercial scheme, then there has to be engagement with the mayor as well. Important in considering your application to get the description of development right. There's something of a conflict between providing enough certainty in the description to enable the Secretary of State to satisfy him or herself that it is a project of national significance on the one hand, and on the other hand, providing the flexibility in the description to enable a scheme to be developed as it's brought forward, i.e. its design and other information supporting it to be developed as the process continues. We're all familiar with the notion of the DCO as the journey, and there needs to be enough flexibility in that definition to enable the journey to be undertaken with such zigzags and wiggles as may be necessary. So there's an inherent tension there. There's also the issue, which again I touched on, about housing, although I'm not sure really whether there really is scope there, but if so, there may need to be some flexibility in the way in which the description of development is brought about. But it's an interesting balance, and of course it will depend in part as to exactly when in the process leading up to an application, when this application for a direction is made. Clearly, if you make the application early, you know from early in the process which route you're going to have to go down. If you leave it till relatively late to enable proper project definition for a proper working up of the case, you may find that some of that flexibility is gone, but you have a much better idea of what you're putting to the Secretary of State and able to make, presumably, a more robust and more certain case on the issue of whether or not it's of national significance. So quite an important issue to think about exactly how the development is described, given where you want to be in terms of when and how and in what terms you're making your application for a direction. Clearly, there are guidelines there. They give a little bit of guidance in terms of the things, and they should be responded to. Make sure that each of the boxes that you can tick is well ticked with supporting material in your application letter. Clearly, the main issue is national significance. Can you persuade the Secretary of State that this project is of national significance? And that's a matter in respect of which a comprehensive case needs to be made. And then again, I've touched on what I've described as the modification procedures, the ability of the Secretary of State in his direction to modify or to deem to have been completed various stages of the DCO process. And again, that's something about which careful thought needs to be made, whether you're seeking the Section 35 direction as a promoter, which is probably the most likely source of such applications, or for infrastructure proper projects, whether you're a third party seeking for your own purposes to have the application considered through that DCO route. And then finally, again, I've picked up on the lacuna in the legislation about the provision of information. Hopefully, by the time you come to apply, you'll be in a position where you've got everything you might conceivably need to satisfy the Secretary of State, either in hand or very close to being in hand, because there is that legislative black hole, really, in terms of the timetable, which if you're not able to respond promptly to the request for information, you might fall into. So be aware and be careful of that. But those are some thoughts really on how one can maximize the chances of a successful direction. Now, once a decision is made on a direction, then the issue of challenges, beloved to us lawyers, arises. And there's been, as far as I'm aware, just the one case in which a challenge has actually been made. And obviously we'll look at that in just a moment in a little bit of detail. But it's worth doing a bit of speculative thinking about where there might be potential angles for challenges through this process. First of all, particularly looking at the business and commercial, is the scheme properly one for which the Secretary of State has jurisdiction to make the direction? Clearly, that would be, if it could be established that it was in effect ultra vires, then that would be a killer point, one would imagine, against a decision to grant the direction. Similarly, if the Secretary of State errs about whether or not it was and thinks it's outside and refuses to grant, then that might provide a basis for an unsuccessful application to be challenged. And I touched earlier on in this discussion about possibly using other sources of definition to inform that debate, with the use classes order being a particularly potentially fertile area. Secondly, the issue of the extent to which the application actually corresponds to the DCO actually promoted. We discussed this potentially thorny issue of housing. Now, it might be that if somebody got a Section 35 direction on the basis of one set of information, but then proceeded to apply for a DCO which was materially different, or in some way, even if it appeared on its face to be a minor change, it actually led to a material difference, there might be a query as to whether or not the original direction could be undermined on the basis that what was applied for wasn't actually the thing for which the direction was given. Similarly, the Secretary of State's use of the modification provisions might give an opportunity for challenge if, for example, they were used in such a way that materially altered the normal rights of objectors and other interested parties to contribute to the DCO process. Then that might give, one would imagine, the ability to bring a challenge. Similarly, if the Secretary of State were to embark upon an extra statutory consultation provision process, if he were to decide to do that, or indeed in some way induced an expectation, a legitimate expectation that such a process would be embarked upon, then again that might give the ability to challenge a direction either made or refused. And then finally, the Secretary of State has a statutory duty to give reasons, and we're all familiar with the concept, not easy to bring off in the real world, but certainly the concept is there for a reasons-based challenge to be made, whether the decision is in favour of a grant of a direction or against, the reasons challenge would stand. And then finally, of course, and theoretically, and as we'll see in a minute from the case law, it probably is pretty theoretical, there is always the ability to challenge the Secretary of State's exercise of the discretion. So there we have some angles now for consideration of how one might challenge, or how challenge might arise on a Section 35 direction decision. And finally, we will look relatively briefly at the only example I've found of a challenge being mounted through the courts to a Section 35 decision. And this is with respect to Stansted Airport, the Stop Stansted Expansion movement. It's a decision of Mr. Justice Dove. And it was a challenge to a decision not to regard Stansted expansion as an NSIP. This is one of those examples where someone who was not the promoter sought to have the scheme brought within the NSIP regime. And the decision was challenged, in fact, on two bases. The first was that the development ought to have automatically qualified as an NSIP. And then secondly, there was a challenge to the discretion, the use of the discretion under Section 35. Briefly speaking, it was a scheme for 2 new taxiways and 9 new aircraft stands. It was phase 3, and this was of some importance. It was phase 3 of a 3-stage expansion project, and it was demonstrably the last stage. The application was made to the local planning authority as a planning application. The Stop Stansted Expansion movement said it should be determined as an NSIP, and the Secretary of State, relevant Secretary of State for Transport, refused that application. Now, in terms of the suggestion that the thing should have been treated as an NSIP automatically, is slightly off-piste for the subject of this talk, but is nevertheless of some interest. The planning application was going to introduce the 1 million passengers per annum from 35 to 43. The threshold for it to be an NSIP was permitted or capable, those are the two statutory words, of a 10 million passenger per annum increase as against the 8 which this scheme proposed. The argument focused around the issue of whether capable meant what the new infrastructure would theoretically be capable of accommodating, or what was the realistic and likely usage based on the particular statutory language for airport expansion. The judge on that ground concluded that it was this was very much a matter of judgment for the Secretary of State. The issue of capability, which is again from the statutory words, was effectively a judgment, and it was a judgment not on a theoretical or hypothetical basis, but the judge says, but an analysis based on how the infrastructure is likely to perform. And given that it was framed in that way, it becomes really a discretionary consideration for the Secretary of State, judgment for him or her, challenger based on Wednesbury grounds, and there was a good deal of consideration in the judgment of the difficulty of challenging a view which was driven by expert considerations and informed expert evidence. The Mott case was relied on heavily. And so interesting in this regard, just in terms of looking at NSIP thresholds, for this conclusion that it wasn't theoretical or hypothetical capacity, but how the infrastructure was actually likely to perform. Also interesting to note that there was a suggestion that the capacity would be materially increased if night flight restrictions were lifted, and it was suggested that that was likely to happen, and the judge concluded that there really wasn't enough evidence to support that, and so that particular issue fell by the wayside. So that was as it were, the NSIP more generally interesting point in the Stansted case. For our purposes, section 35, the conclusions were pretty stark and not really terribly surprising. The judge concluded that it was a broad discretion, and he then said, pretty unsurprisingly, that the task of the claimants in seeking to undermine such a broad discretion is daunting, and clearly it is. And although there were various attempts made to suggest that there were matters to which the Secretary of State had not had proper regard, either by misinterpreting policy matters or by misconstruing the facts, that they all failed. So, for example, it was suggested that the Secretary of State hadn't appreciated that the expansion scheme was part of a larger project which would have increased the capacity to such an extent that the matter ought to have been considered as an NSIP. And for example, there were suggestions in the correspondence about a higher figure having been considered at an earlier stage in the proceeding, and there was quite a lot of discussion about various meetings in which numbers had been tossed around, but the judge eventually came to the conclusion that the proper forensic construction of those discussions was that they weren't really part of a concrete material proposal to which the Secretary of State would have been obliged to have regard, but were merely entirely theoretical discussions about various aspects of the infrastructure capacity, and so the alleged failure to consider those wasn't regarded by the judge as a failure at all. Similarly, there were considerations about carbon emissions, and that was suggested that they had already been dealt with through national policy documents, not an NPS in every case. So there was the making best use of existing runways document, and then the airport NPS did touch on various elements, and it was held that the Secretary of State was entitled to have regard to the fact that those considerations had been made, even though he wasn't prepared to suggest that the project itself should go through the NSIP regime. And finally, with respect to the economic effects, there wasn't any evidence that they were any more than regional. And so what one took away from the Stansted case, the matters relating to the difficulty of challenging judgments, the issue of what the infrastructure is actually likely to bring about, but important for our considerations of the Section 35 jurisdiction, the very broad nature of the discretion and the ability in that broad discretion for the Secretary of State to rely on matters already decided by national policy. So The only challenge we've seen, it might well be concluded, points out some real difficulties, as will always exist in challenging what is a very broad discretion, in respect of which the procedural provisions are not exactly detailed. And so an unsurprising result, but really pointing out some of the essential features of this regime, which I've tried to illustrate this afternoon, in terms of the two-headed nature of, first of all, infrastructure proper versus business or commercial, some of the definitional difficulties in infrastructure proper, the need to respond to the guidance that's offered when making the application, but beyond that, there being no particular procedural route, and the importance of whatever route you use, however the documents are constructed, of dealing particularly with this need to persuade the Secretary of State that it's a project of national significance, and thereafter, when the decisions are made, really the possible grounds which we've touched upon for challenging, but also the likelihood in practice of it being really quite difficult to challenge a Secretary of State's decision. So there concludeth my consideration of section 35. I hand now back to Harry, who will introduce part 2 of this webinar. Harry.
Thank you very much, Andrew. Fascinating stuff and very clear. Thank you. So hopefully we're now ready to hand over to Craig and to Michael, who with any luck will appear on our screens. There he is. Craig, over to you to deal with MPSs.
Thank you very much, Harry. I hope I can be seen, and I hope I can be heard clearly. Michael and I are going to talk about national policy statements, and we're going to focus our attention on the question of the need for review. It goes without saying that national policy statements are extremely important, and they form a pivotal part of the statutory scheme. But their importance should be reflected in a position where the policies are kept up to date. And the current position, you may think, is rich with irony, bearing in mind the criticism placed by politicians on local planning authorities for not having their development plan up to date, when the Secretary of State, at least in the view of many, is not keeping up to date the national policy statements. The structure of our presentation is set out on that slide, and Michael and I are going to box and cox so far as the slides are concerned. So Michael, next slide, please. Now, of course, many of these provisions will be familiar to most of you, but I want to look at the most relevant sections and flag up those that are particularly important in the light of current issues and the questions about whether or not the Secretary of State's statements are properly up to date, and if not, what to do about them. Section 5 is the foundation for statements, and we note in particular there that they not only set out the questions related to policy, but they're so important, hugely important, because they may set out the appropriate amount, type, or size of development. Indeed, they may set out criteria to be applied in deciding whether a location is suitable. And they do a number of other things. So their importance and the pivotal function they have in the statutory scheme cannot be doubted. Next slide. Now, section 104 is obviously important. This slide deals with the role of statements in decision making, and section 104, and in particular subsection 3, is of critical importance. In essence, giving a presumption in favour of the national policy statement so far as it benefits the proposal in front of the examining authority and Secretary of State. However, that presumption is qualified by the specific exceptions set out in subsections 4 to 8. And I just want to draw your attention now to, in particular, to the 4th bullet point there. That's the question of adverse impacts outweighing the benefits. So that's a particularly important qualification to the presumption in favour of applications that accord with the relevant policy statement. Next slide, please. Section 1061B, of course, has to be borne in mind. That is the effective preclusion of the questioning of the merits of a policy statement. And that is reflected in other provisions of the statute, such that the examining authority may similarly disregard any such representations, indeed refuse to allow them at a hearing. Next, please, 105. Now, this section is important because it deals with the situation where there is no relevant NPS in place. In this circumstance, the Secretary of State has to have regard to other matters, the local impact report, prescribed matters, but also any other matters which the Secretary of State thinks are both important and relevant to the Secretary of State's decisions. Now, that's important because an NPS may still be important and relevant even if it doesn't directly apply to the proposed development. And similarly, an emerging NPS may be important and relevant. Indeed, that is reflected on the National Infrastructure Planning website. So I turn next to section 5. I've already referred to this section. I now do so in order to pick up 3 subsections in particular. First, subsection 4, designation only if the relevant consultation and publicity requirements and parliamentary requirements have been complied with. We will touch upon later the fact that that subsection in effect provides hurdles and delays to the process of designation and review. Subsection 7 is important. That should say NPS. There needs to be reasons for the policy set out in the statement, and those reasons must include an explanation of how the policy takes account of government policy relating to climate change. Please bear that in mind because it's relevant in one of the recent cases. And so is section 10. That's the duty on the Secretary of State to carry out his functions of designation or review with the objective of contributing to sustainable development. And he also must have regard to the desirability of mitigating and adapting to climate change. Section 6 is the specific section dealing with reviews. And it's important, and I'm particularly flagging up not just the fact that part of a policy statement can be reviewed. I'm also asking you to bear in mind for what comes section 3, section 6, subsection 3 and subsection 4. In deciding when to review, the Secretary of State must consider whether there's been any significant change in circumstances, whether that change was anticipated, and if it had been anticipated, whether any of the policy would have been materially different. That subsection is really important in terms of the Secretary of State's approach to the question of when to review. And it provides hoops for him and hurdles for others who are seeking to persuade the Secretary of State to review statements. Section 11, please. This deals with NPS suspension, and it broadly follows the same formula as significant changes seen in Section 6, providing an additional power to suspend a statement whilst it is being reviewed. The next slide is there for completeness because it refers to some of the details in Section 7 dealing with consultation and publicity. Suffice it to say that there are procedures set down within that section to be further developed in regulations, and they can add to the hurdles to be crossed and the delays to be encountered in the process of review. Just as Section 9 on the next slide indicates quite clearly the difficulties that can be encountered when statements are proposed and reviewed through the course of Parliament. In other words, where amendments are made following recommendations, the process has to start again, and there is a rather circular process indeed. Section 13 I provided for you in a slide because Michael is going to, I think, just touch upon it in the context of the ability to challenge by judicial review the DCO decision. So there I've set out the framework, and I'm now going to ask Michael to take over to speak about the current statements in place.
And good afternoon, everyone. First, a summary of the current designated national policy statements. For ease of reference after the presentation, I provided a list of all current NPSs. Given the emerging thesis of this seminar, the dates of designation are the key bits of information I would suggest. And the energy NPSs were all designated in 2011. The other NPSs were later, some passing largely unnoticed into designation and some attracting significant controversy. There have been 12 designated NPSs, although you will all be aware that the airport's NPS is subject to ongoing litigation, which Craig will discuss later in this talk. There are 2 emerging NPSs. The draft NPS on water resources, which was consulted upon by the government in early 2019, and it was then subject to an inquiry by the Environment, Food and Rural Affairs Committee. And it's useful to note the committee's terms of reference as it shows the breadth of submissions called for by the committee. Note in particular the last 2 bullets, the effectiveness of consultation and anything else you care to mention to the parliamentarians. The latest government position on the water resources NPS was that it was considering the consultation comments and the committee's recommendations and aimed to lay the final NPS in the autumn of last year. So far as I'm aware, there's been no further progress and there's no expected date for designation. EN6, the nuclear power NPS, listed 8 sites suitable for the deployment of nuclear power stations by the end of 2025. As far back as December 2017, the government consulted on a new NPS for nuclear power for deployment between 2026 and 2035. The new nuclear NPS was announced at the same time as the geological disposal NPS, which was adopted in October of last year, but as yet we don't have the new nuclear NPS. Hereward Phillpot QC has already presented a seminar on nuclear, so I'm only making brief reference in this talk where relevant to the points we're seeking to make. But to date, nothing further on new nuclear NPS, but the government aims to designate it, we are told, in 2020. I've seen some commentary online about possible additional NSIPs and NPSs, so I thought it'd be worth a brief speculative mention today as food for thought. I think the demands and opportunities of the post-COVID-19 recovery might, just might lead government thinking into new directions. However, at present, unless there are significant amendments to the 2008 Act, I think a housing-focused MPS is a pipe dream. Residential development is not in itself a nationally significant infrastructure project under the Act. There is some thinking in the area, particularly around garden villages, but that's a topic for another seminar. I think in terms of NPSs, business and commercial projects are perhaps more immediately interesting. Andrew has looked at business and commercial projects as regards Section 35, and the current position is that if a business and commercial project is designated under Section 35, it would proceed under Section 105. There's no NPS, and as Andrew noted, the scope is wide, and there might never be an NPS. However, when the government originally consulted on business and commercial projects coming into the NSIP regime in 2012, 42% of respondents disagreed with the proposal not to have an NPS. I imagine now that the figures for disagreement with that proposition would be higher, particularly in light of the spate of recent local plan problems. One interesting question is whether the lack of an NPS is one of the reasons why there has been so little uptake of business and commercial NSIPs. A few have been withdrawn, but there are currently only 2 pre-application projects listed on the infrastructure planning website. The door remains open to an NPS on business and commercial projects. The explanatory memorandum to the 2013 regulations explained that the position would be kept under review. My view is that as we move to more online shopping, the need for supportive infrastructure such as large warehouses increases, the time for a business and commercial NPS is potentially coming. I'm now going to hand back to Craig, who's going to discuss some of the recent cases in this area.
Thank you very much, Michael. Yes, now recent case law. In terms of statements and the attacks made on statements, there are 4 current cases, and I'm going to speak in a little bit of detail about the first 2 and the reasons why we will speak less about the second 2 will become rather obvious in a moment. So turning to the Plan B Earth case, this is the Heathrow case and the National Planning Statement for airports and the ongoing litigation. And our focus is on the Court of Appeal judgment. Of course, in the Divisional Court, a multitude of questions were considered. There was a refinement of grounds in the Court of Appeal such that there were many less subjects for consideration. I'm focusing on a particular aspect which is relevant to Section 5, subsection 8, which you will remember I drew attention to at an earlier stage, the reference to climate change. Now, it was common ground in the case that in deciding to designate the statement, the Secretary of State did not take into account the government's commitments under the 2015 Paris Agreement. Now, although the case related to a number of other things, such as the Habitats Directive, the SEA Directive, and so on, there was only one ground which succeeded, and that was that related to subsection 8 of section 5. And it was held that the government's commitment to the Paris Agreement constituted government policy on climate change, which, pursuant to subsection 8 of section 5 of the 2008 Act, the Secretary of State should have taken into account. And his failure was enough to vitiate his decision to designate the statement. Further, it was said that the matter, Paris Agreement that is, was so obviously material to designation that it was irrational of him not to have taken it into account. So I want to make 6 short points on this case. The first is that the focus was on subsection 8. And you'll remember that is the obligation to give reasons which include an explanation of how the policy set out in the statement takes into account government policy relating to climate change. It's important, indeed, the court made it clear that that subsection does not require the Secretary of State to follow the government policy on climate change, but it must, in the statement, explain how it has been taken into account. The second point is this, that government policy within subsection 8 is an ordinary English frame of words, and it has no specific technical meaning. It's broader than legislation, the court held. Thirdly, the government commitment to the Paris Agreement was government policy. Of course, the Paris Agreement is an unincorporated international agreement, but in the broad terms of the Planning Act, it qualifies as a government policy in subsection 8. The fourth point is that the Secretary of State should have taken it into account, therefore, in other words, its implications for the decision and whether or not anything different should have been put into the statement on the basis of targets under the Climate Change Act. The fifth point is, and this is also worth noting as important to tie in section 10, you recall the duty to act bearing in mind the objectives of contributing to sustainable development and with regard to climate change, the decision was flawed for similar reasons. The sixth point to take away is that the court decided not to quash the decision, but to make a declaration preventing the statement having any legal effect until the review under section 6 was completed. Now that's particularly important because there may have been a hope that the court would have actually quashed the statement, meaning that it was de facto from here on. But the court was quite careful and in particular noted with some emphasis that the statute provides a built-in mechanism for review, to which I've referred at an earlier stage of the presentation. So those are the 6 points. The last bullet point notes there that the matter is going on to the Supreme Court, as I understand it, on the section 5 subsection 8 issue. But for the moment, if that's right, please bear in mind that the other matters discussed in the Court of Appeal judgment remain as settled law, and they include findings as to the standard of review when considering requirements under Article 6.4 of the Habitats Directive, and also the approach of the court to questions on environmental reports and compliance with the SEA directive. The next case is the Client Earth case, or the Drax decision. This was a judgment, recent judgment by Mr. Justice Holgate, who had sat, of course, in the Divisional Court on the airports statement case. Now, this was a challenge to a DCO decision on the basis of the Secretary of State's interpretation of the statement EN1. In fact, the Secretary of State's interpretation was upheld. It was the panel's interpretation that was found to be wrong. The court found that EN1, taken as a whole, does not require a general quantitative assessment of need in DCO decisions. That was the contention made to the panel, which the panel accepted, and the court said that the statement read properly and as a whole, in accordance with the principles of Tesco-Dundee, does not require an assessment of need in order to justify DCO proposal. What EN1 does say is that there is a qualitative need for new development such that substantial weight can be given to the contribution from an individual project, which was a rather different proposition. The court also found that when carrying out the balance, that's adverse effects against benefits, you recall, under section 104, subsection 7, the Secretary of State was entitled to take into account the substantial weight that she had taken into account by reference to the need element when considering the statement EN1. This case is also important because it provides confirmation from Mr. Justice Holgate of a number of principles that have been taken from Spurrier, that's the divisional court in the airports saga, but also other cases such as the Scarisbrooke case. First, the merits of statements are not open to challenge. Secondly, an emphasis on this proposition that section 104 subsection 7, the balancing exercise, is not to be used to circumvent subsection 3, in other words, the primacy given to the relevant statement. However, Mr. Justice Holgate did explain that the preclusive effect will depend upon the wording in the statement. And this, I think, is at the heart of the particular facts of this case, where EN1 did say something about substantial weight. The fourth point, confirmation, if you like, is the court once again drawing attention to the appropriate procedure for arguing a policy is out of date. That's the section 6 review mechanism. And in this case, that was important for him to state, because he took the view that actually Client Earth was doing no more, as he said, providing a barely disguised challenge to the merits of the policy. What they contended was, because of what had taken place since 2011, there was no need for any future new large gas fuel power stations to be built. So in effect, that would, if it had succeeded as a submission, would have had the effect of fundamentally undermining the proper interpretation of the statement EN1. Client Earth has applied for permission to appeal to the Court of Appeal, and it's in this context that I can ask you to note that the other case that I referred to, the Riverside Energy Park DCO decision, has been given permission to apply for judicial review. And hot off the press this morning, I've managed to be given, and I'm grateful, a copy of the permission order from Mr. Justice Carr. And of particular note is the observation he made when granting permission along these lines. I find it difficult, the interrelationship between, on the one hand, the proposition that the need for the NSIP is settled by the statement and not open to challenge, and on the other hand, the logic that the contribution of the individual NSIP to meeting the need is intrinsically relevant to whether the harms outweigh the benefits. And so what he's drawing attention to there is, notwithstanding what Mr. Justice Holgate had said in the judgment, Mr. Justice Carr felt that there was sufficient there to have further argument on this apparent tension between the two subsections there to which I've drawn attention to, the balancing exercise and the primacy duty. Next slide, please. I think Michael takes back to your slides. Thank you very much.
I imagine that most of you will be aware of the Good Law Project judicial review proceedings challenging the government over the energy MPSs. There's been a great deal written about the proceedings, mostly by the claimants themselves, who have not shied away from publicity. Helpfully though, the Good Law Project have published the pre-action correspondence they've had with the government, and their own statement of facts and grounds. So we can see at the heart of the Good Law case is that there's been a significant change in circumstances since the designation of the energy NPSs, notably the net zero carbon emission target by 2050. The government's pre-action position was that the challenge was premature as there was no decision. There were some noteworthy points made in the correspondence, which I'll draw to your attention. The first is that the government's still going through the legislative and parliamentary process for the new nuclear NPS. It hasn't been kicked in the long grass, and it is coming. But at the same time, the government said it was also actively considering whether it was appropriate to review all or parts of the other energy NPSs, which sounds like it's within the statutory provisions at the start of the 2008 Act. So the second point is then Good Law Project wrote back and asked what the active consideration was. And we now know that this consideration was being undertaken solely by officials, which Good Law have characterised as the Sir Humphrey decision. The Secretary of State has not considered a review of the NPSs, and officials did not anticipate asking him or her for at least a year until after the publication of the Energy White Paper, which is now expected mid-2021. As I understand the position, proceedings in Good Law commenced on the 18th of May, but no decision on permission has yet been made. Some of our listeners may know better than I, and I'm sure it will pop up in the question and answer box shortly. I think the challenge faces some significant hurdles, not least the effect of Section 13, and the challenge attempts to manufacture a decision to challenge. But it's a case to watch, particularly if it gets permission. And that leads me on to what we consider to be relevant considerations for the Secretary of State in his or her approach to the review of an NPS. The starting position in this analysis is Section 6, as already been identified, and this is simply a quick reminder of what the Secretary of State must consider when deciding to review NPS. My thesis is that it's certainly arguable that there have been significant changes which were not anticipated, particularly with regard to the energy NPSs, and I would suggest they are now aging and starting to creak at the seams. Mitigation and adaptation to climate change is built into the Secretary of State's designation and review of NPSs by Section 10, but absent any review, the climate change considerations which apply in examination are as set out in the NPSs to the extent that they do. And given the rapid and increasing focus over the last decade on decarbonisation and the climate, it must be questioned whether or not 10-year-old documents, well, roughly 10-year-old documents, are really up to date. And by up to date, I mean past their sell-by date, as opposed to having any legal expiry date. The age of NPSs is proving to be fertile ground in challenges at examination, and as has been explained, in the courts. By way of example, I've highlighted on the slide a few immediate issues that I can discern with the current crop of energy NPSs. We've already discussed the cessation of EN6 policy support for nuclear locations, so I'll skip straight to EN3. And I would suggest it's surprising in 2020 that EN3 on renewables has no policy support for tidal stream, wave, or solar energy. The government commitment in EN3 was that when it appears that other renewable technologies will be economically and technically viable over 50 megawatts, the government will further consider either revisions to this NPS or separate NPSs to cover such technologies. That's a good indication there of what the Secretary of State considered then to be significant changes within the meaning of the Act. But as you will be aware, nothing has happened. By June 2015, Tidal Lagoon Swansea Bay was consented under Section 105 for a nominal 240 megawatt tidal range generating station. I helped promote that scheme, and I was very sorry to see the DCO lapse recently. But the fact remains, there are still no changes to EN3. EN1 is also becoming increasingly controversial in my view. It continues to point to the need case for fossil fuel power stations, including coal. In Q1 of 2013, coal power generation accounted for roughly 39% of the UK's power. but by 2018, it was down to 8%. And my understanding is that since the 10th of April, around lockdown this year, no coal-generated power has entered the grid in Great Britain. Yet if a coal-fired power station were to come forward now, the government's position, and see the Drax decision letter at paragraph 413, is likely to be that the presumption that all forms of electricity generation are needed, including coal, has already taken decarbonisation and climate change into account. That position, I would suggest, is particularly unsustainable now in light of the government's policy to phase out all coal-fired power generation by 2025. The next bullet there on COVID-19, it had to come into a seminar, but it's pure speculation. But if changes in working practices due to COVID-19 and or greater carbon footprint awareness do last, there will be significant changes, I'd suggest, in working and living patterns. And I hope you're all sat at home now enjoying this seminar. And that's going to rapidly age the assumptions which underlie, for example, the national network's MPS. My contention is that the MPSs may not be flexible enough to respond to relatively rapid societal changes, particularly when the bureaucracy are, quite properly, focused on combating a pandemic and or recession and or Brexit. Review seems particularly unlikely now. And that really feeds into the last bullet on my slide. There's a common thread, I'd suggest, which runs through the recent cases and the potential challenges. There's, in my view, a lack of political and bureaucratic will to even begin the process of the review of MPSs. Particularly now, government just doesn't have the bandwidth. It's entirely focused on COVID. And this is a real concern for infrastructure development. Given the primacy of the MPS and the inability to challenge the MPS at examination and the policy support for what is now seen as undesirable development, it leaves a real policy issue, which is being highlighted in cases like Drax and Riverside Energy Project. The government's path out of the COVID-19 lockdown, we're told, includes infrastructure and levelling up. But there's now a potential question about whether or not that will be the right infrastructure in the right place with the right support. The 2008 Act system was designed to operate with clear, up-to-date MPS guidance, which would shorten the consenting time, as many of the potentially controversial issues were settled by the MPSs. However, if the government allows the MPSs to get stale, the DCO procedure will come under increasing challenge as the MPSs themselves become sources of controversy. So Craig and I have thought about what promoters might do to seek to insulate their projects from MPS risk, as we would term it, and how objectors, on the other hand, might capitalise on that uncertainty. As the audience will be well aware, the project life of a DCO is significant, and the preparatory work leading up to examination and decision is the work of years. Plainly, as MPSs age and continue to do so, there is potential that there will be a review of the relevant MPSs over the application lifetime of projects which are in contemplation now or shortly to come forward. I think that promoters need to take a wider view, monitoring the challenges coming forward and the grounds which are raised by them. As the airport's litigation has shown, there's a risk that the courts will declare an MPS unlawful and of no legal effect. And although that was decided on very particular facts, and I'd suggest the risk therefore is relatively low, equally a Secretary of State may be prompted into a decision to review and might exercise his or her power to suspend an MPS. So any promoter ought to be prepared to challenge decisions of the Secretary of State as necessary. The risk otherwise is that the goalposts are going to shift during the match, i.e. during application and examination or shortly afterwards, which creates some of the problems faced by the Drax litigation. The practicalities of the slightly nuclear option will be discussed further by Craig, and that's to consider whether the Secretary of State ought to be prompted or could be prompted to review the MPS, the relevant MPS for a particular scheme, in advance of an application. Given the front-loading preparatory work of a DCO, the timescales may match up, albeit that the current emerging MPSs, as I've said, are yet to emerge from the long grass. But it's a high-risk strategy. The best outcome is that the Secretary of State might support the extant NPS or only review small parts. But really, it's rolling the dice, and decisions involved in a review are susceptible to challenge by third parties. So what approach could be adopted at examination? Objectors to DCOs already have made indirect attacks on the MPSs, Drax and Riverside Energy being prime examples. And I think there are risks in simple reliance on the need case as set out in the MPS. Need can be addressed in the statement of reasons, but I think an explicit project benefits document emphasising the credentials and the need for the project is very effective if done properly, and it's hard to counter for objectors, and particularly in shaping that approach to the balancing exercise under section 104(7) of benefits against disadvantages. It may be an obvious point, but it's also important to note the approach of the Secretary of State to the declaration that the airport's MPS was unlawful. I note that the online guidance on the National Infrastructure Planning website and the government's own website makes no mention of the loss in the Court of Appeal, but lots of the win in the High Court. But in the recent Manston Airport decision, the Secretary of State afforded the airport's MPS no weight, as you see on the slide, quite properly, I'd suggest. However, a suspended, emerging or under review MPS may still carry weight under section 105 of the 2008 Act as an important and relevant matter. And it's up to the Secretary of State what amounts to an important and relevant matter, which gives him quite a wide discretion. This is a significant difference from, say, material considerations under the 1990 Act, which are a matter of law. The approach to the new nuclear MPS is perhaps illustrative of the approach the Secretary of State may adopt going forward. Although the written ministerial statement originally in 2017 suggested that EN6 might not have effect after 2025, which in passing I don't think is technically the correct position, the government made plain that it would give significant weight to EN1 and EN6, even if they did not have effect for the purposes of section 104, unless either MPS had been suspended or revoked. That position then changed in the later consultation material for new nuclear, and the government made plain that it viewed the existing and emerging MPSs as important and relevant considerations, the implication being that any attempt to exploit the uncertainty between the two will be crushed between those two positions. To summarise, my view is that promoters and objectors to DCOs need to be realistic. Is the MPS out of date? Is it creaking at the seams? Is it too old? At examination, those are issues to address head on, and if you're objecting, the points to make can usually be put as benefits versus impacts balancing points under section 104(7, rather than explicit challenges to the MPS which are doomed to fail. Although, as Craig has mentioned, note the current position following Client Earth. You can't use that to circumvent the primacy of the MPS under 104(3. And that's even where a change of circumstance has occurred or material has come into existence after the designation of the MPS. And the court has also made clear that it cannot be argued that any change in circumstance should reduce the weight to be given to an MPS. So if you're promoting, on the other hand, it's plainly possible to anticipate the issues with an ageing MPS. Don't rely solely on policy support in the MPS, but of course look very closely at any objections to determine whether or not they're in fact challenges to the MPS, or if you can characterise them as such. Where there are particular controversies, promoters can offer up requirements to mitigate any potential MPS risks, and I've seen this done very effectively during examination periods. Lastly, except that until reviews, particularly of the energy MPSs, are carried out, there will be uncertainty, and the potential for challenge will exist, and promoters should build challenge periods into their scheme's critical path. which does rather chip away at the certainty the 2008 regime is meant to provide. I will hand you back now to Craig for the last time to look at the scope for influencing those MPS reviews should they come forward.
Thanks very much, Michael. So that really looks at the DCO process and the application process, considering what can be done there. Of course, it's always open outside of a DCO application to seek to persuade the Secretary of State by making representations to the Secretary of State, by lobbying from expert bodies, the lobbying of MPs to raise issues in Parliament. All those can and are done in order to seek to persuade the Secretary of State to review an out-of-date policy statement, or one that is said to be out of date. But Michael referred to rather an apt phrase in the NSIP context, the nuclear option, by which he was referring to taking judicial review of the Secretary of State's handling of the very question of the use of his power under Section 6. And in essence, that's the Good Law Project claim. And it's a really exciting case in this context. It starts new questions for the courts in the context of the 2008 Act, and it deals with a range of really interesting legal issues. The contentions that are made in that case in very short term are, and I should pause here simply to say that we have gone over time, probably got about 5 more minutes if those of you that are still with us, and there are very many, can bear with us for a bit. Apologies for that, but probably about 5 minutes or so, and then the presentations will be finished. So the good law claims, first they said, having regard to the requirements of Section 6, that there have been significant changes, and there's a list of them in the letter before action. The primary one being the Section 1 Net Zero Amendment to the Climate Change Act, and the implications that has, taken together with the Paris Agreement, of course. Secondly, the claim contends that such changes are obviously significant changes, such that it was quite irrational. It would be quite irrational if the Secretary of State didn't reach the conclusion that that particular hurdle in Section 6 was not crossed. And thirdly, it's contended that if in 2011 the EN statements had anticipated what was going to happen, the policy wouldn't have been materially different. Now, those contentions, as I say, exciting though they are going to involve the court in a number of problematic areas. The claim, I suppose, could be said to have a good head start insofar as the Court of Appeal in the Plan B Earth case, of course, as we've seen, concluded that the Paris Agreement was, you recall, so obviously material to the airport's statement decision that it was irrational not to take it into account. So that's quite a good start in terms of approach with reference in particular to the Paris Agreement. However, everything else seems to suggest that the claim is going to have to grapple with some hard-edged and protean issues of law, such as, for example, those that have already been considered to an extent in the Spurrier litigation. So one of the issues will be having regard to the breadth of the discretion under Section 6 in particular. At first blush, that discretion appears to be very wide for the Secretary of State. So there's a hurdle for the claimants. Secondly, the court will have to deal with the question of what degree, what intensity of scrutiny it can adopt when considering the exercise of that discretion in terms of approaching its rationality or otherwise. It's also going to have to deal with the normal prospect of judicial review, carrying with it quite a heavy burden, but in this case, quite a heavy evidential burden. And the claim, of course, contains, as I see to my left, a long list of technical documents that are there in support of the proposition that it's quite irrational for the Secretary of State not to decide to review the statements. And of course, the court is always going to apply considerable caution in particular cases such as this, for example, where there is such bountiful areas of technical expertise. It might be said that the Secretary of State, following the Mott principles, has a margin of appreciation in terms of the exercise of his discretion. So we shall wait and see. The next slide is really a recognition of the other alternative, which is to adopt the rather quieter, less nuclear approach of applying pressure on the Secretary of State, in which case that can only be done persuasively by taking advice from the relevant experts and building up a proper evidence-based representation, taking into account what is perceived to be the government's direction of travel. And of course, lobbying in the normal way, I say the normal way, it should be done in the normal way on both sides, in both houses, in order to gain and garner support to apply further pressure on the Secretary of State. So by way of conclusion, and because we've gone over time, I don't want to spend long on this, but it's quite clear from what we've said that in the context of the importance attached to national policy statements, the question of whether or not they are up to date is absolutely critical. Not only does it give rise to attention in the Act itself, most vividly seen in the approach to need and the status of the statement under 104, and also the balancing exercise to be exercised under the statute. Remembering that the statements, of course, remain effective until they're reviewed. And even now, as Michael has indicated, there's some perfectly proper arguments that they are at least yellowing at the edges. In truth, reviews will depend upon political will. So there is the scope to influence the Secretary of State. But as I've indicated, the good law claim provides a rather more hard-edged opportunity for updating certain policy statements. There's only one bit of further advice I can give you that Michael have thought is worth making when you do seek to lobby the Secretary of State. Ensure that you don't wine and dine with the Secretary of State while you have a DCO application that's been considered. The Westbury Printworks case has long arms. That's all that Michael and I wish to say. I hope you found it informative. Harry, back to you.
Thank you very much, Craig and Michael, bringing to an end an excellent set of presentations. Now, we're all back on screen. We've had a few questions which we'll just deal with briefly before we part ways. So the first question I want to deal with comes from Mary Shipman, who explains that BEIS has very recently announced a review of the need to coordinate the connection of energy projects into the onshore distribution grid. Will this affect EN1 and EN5? Now, that's a question I think probably I'll pass to you, Michael, in the first instance, but by way of initial comment, it can't, I suppose, legally affect EN1 and EN5 per se. The statute has a very clear process, as has been explained, for the review and update or change or withdrawal of MPSs. But one might imagine that the Secretary of State would regard that as an important and relevant consideration. But that's by way of sort of initial comment. But Michael or Craig, anything that you want to add in response to that question?
I've not seen the actual announcement itself, but I agree it would be an important, relevant consideration. And given the thesis in my slides, I think it's probably also a policy statement which what one might argue is a significant change for the purposes of considering whether or not the EN1 and EN5 are up to date to prompt a review. But as Harry has said, it doesn't technically have any legal effect on what's going on with the MPS or the consenting procedure under the 2008 Act.
I think that both illustrates one of the strengths, but also perhaps one of the weaknesses of the Planning Act system. It's strong in that the policy statements are intended to be enduring, and they're intended to provide certainty for promoters for projects which have very long gestation periods and where financial investment depends on a stable policy background, one that doesn't change on a regular basis. But it also does reflect one of the downsides of that, which is perhaps it's not as light on its feet as it might otherwise be. And picking up some of the points that Craig and Michael have been making about where you do have a period of rapid change in the background information, it's less well able to respond to that. So pros and cons. Finally, there have been a couple. Sorry, Craig, did you want to
pick up upon your reference to the statute and plainly the importance given to the duration of statements? But of course, it seems to me, and it may be a matter picked up in the good law claim, that there must come a point at which it could be arguable that Parliament never intended the statute to be operating in a way which allowed DCO applications to be, in effect, determined, at least in relation to need, by reference to a document that was plainly out of date. That's a sort of Padfield type argument, and I wonder whether that might be part of the good law claim. But it's an interesting concept anyway. That's as far as I've taken it.
I suspect that running that challenge in court might be the daunting prospect that you were referring to earlier, bearing in mind that it's Parliament that decides when these things ultimately get reviewed. But that's there's obviously quite a lot in there we could go on and deal with. But let's just look at the other 2 points. I think Nuno Fernandes has provided some information in relation to possible updates of policy. I don't know whether, Michael, you have any comment on those?
Not much comment, but it's useful. We're told that MPs from the EFRA committee have said that the Water Resources MPS is going to be released in the spring. Presumably that meant the spring we've just had, and I'd suggest we're in summer now. So perhaps spring of 2021 is the new target. And there was also an announcement that I've also not seen about the energy white paper. Apparently the B's Secretary of State has now said that it's going to be published with the autumn statement, so coming forward slightly earlier than they indicated in their pre-action letters in Good Energy. I think that's we shall see whether or not that really does come forward in the autumn, given everything else the government's got to think about between now and then.
Yes, quite a few of these strands are interconnected. Once you start to pull on one bit of policy, other bits of the energy policy are affected. So it'll be very interesting to see, as you say. Well, look, I think that brings us to the end of our session. Thank you for our 3 speakers. Excellent presentations, and thank you all for attending. We hope you found it helpful. Now, as many of you will know, this is one of a series of regular infrastructure webinars that we've been putting on during the course of lockdown, and they'll be carrying on into the autumn. So please do look at our website for details of forthcoming events. There'll be more of this to come. And in the meantime, I hope you all have a pleasant summer and wish you farewell. Goodbye, everyone.
Thank you, everybody. Goodbye.